I want to thank the Law School Alumni Association, also the Criminal Justice League, and the National Lawyers Guild for co-sponsoring this event with us. My name is Jim Mayer. I'm a staff attorney with the Great North Innocence Project. The Great North Innocence Project works to free the wrongfully convicted and to prevent future wrongful convictions in Minnesota, North Dakota, and South Dakota. I'm thrilled to be here today to introduce you to this distinguished panel that we have. And I'm going to start in the middle as the Joseph Flom Special Counsel and Director of Strategic Litigation. Chris Fabricant leads the Innocence Project's Strategic Litigation Department, whose attorneys develop and execute national litigation and public policy strategies to address the leading causes of wrongful convictions. Talking about, we're talking about things like eyewitness misidentification, false confessions, and the topic for today, which is the misapplication of forensic science. Over a 20-year career in criminal justice, Mr. Fabricant has served as a clinical law professor, as a trial counsel, as appellate counsel. He's the author of numerous scholarly articles on forensic sciences, and he is the author of the book, Junk Science and the American Criminal Legal System. The book is timely, it's informative, it's actually a pleasure to read. It's available for purchase in the bookstore. Chris is going to hang out after this. If you want to get a book signed by him, he'd be happy to do that for you. So please welcome Chris Fabricant. The man to my right needs very little introduction in Minnesota, but Keith Ellison has served as our Attorney General since January 2019. He is the lead prosecutor in the matter of the May 2020 death of George Floyd in Minneapolis. He led the team that successfully convicted former Minneapolis police officer Derek Chauvin on a charge of second-degree unintentional murder, which resulted in the longest sentence of any police officer for killing a civilian while on duty in Minnesota. Attorney General Ellison also led the team that successfully prosecuted former Brooklyn Center police officer Kimberly Potter on a charge of first and second degree manslaughter in the matter of the April 2021 death of Dante Wright. Attorney General Ellison believes that the prosecutor's job is not merely to win at all costs, but to be a minister of justice. And to that end, Attorney General Ellison has partnered with the Great North Innocence Project to start Minnesota's first conviction review unit with the goal of evaluating, identifying, remedying, and ultimately preventing wrongful convictions in Minnesota. Please welcome Attorney General Keith Ellison. Last but not least, Dr. Lindsay Thomas is a board-certified forensic pathologist. She received her medical degree and completed her residency at the University of Michigan Medical Center. She completed her fellowship in forensic pathology at the Hennepin County Medical Examiner's Office, where she worked as assistant medical examiner. She's also served as medical examiner for the Minnesota Regional Medical Examiner's Office. Currently, Dr. Thomas does locum tenens work for medical examiner offices in Reno, Nevada, as well as Salt Lake City, Utah, and she consults with criminal and civil attorneys. Dr. Thomas has been a longtime supporter of the Innocence Project and has been on the board here in Minnesota for several years. She has extensive history testifying as a medical examiner, forensic pathologist, including serving as an expert witness for the state in the Derek Chauvin murder trial. Please welcome Dr. Lindsey Thomas. Mr. Fabricant, I'm going to start with you and maybe start with definitions. You've written a book about the use of junk science in our courtroom. If you could let us know what you mean when you use that term and give us an example of junk science from your book.
Well, the way that I define it in the book really is, junk science is kind of a pejorative term, and there are lots of people who, take great umbrage at this phrase. And so I was trying to be very careful about the way that I defined it, which was subjective speculation masquerading as scientific evidence. It's something that sounds like science, but there's no empirical basis for the opinion being offered. There isn't a basis in scientific literature, isn't in research. Usually it's based in training and experience and kind of received wisdom that's kind of passed down through generations of very prominent practitioners of a particular field, but it's lacking an empirical basis.
Can you give us an example of junk science, maybe from your book that you discussed?
Yeah, the paradigmatic example is probably bymark evidence. Bymark evidence is the purest form of junk science because there's really nothing that can be said about it, right? The evidence is that experts who board certified experts are no better at identifying a bite mark as such as you and I would be. The literature says it's like flipping a coin. And when you see, the entries in casework, the entries that I have seen, it looks nothing like what you're probably thinking of right now is when your toddler comes home from daycare and they have those neat little bite marks that like an obvious bite mark. That's not what you get in homicides or in assaults, and to say nothing of being able to associate a particular bite mark with some particular dentition. There's no evidence that the teeth are individual or unique. And certainly they probably are, but whether or not that uniqueness could be transferred to skin is, it can't be. So there's that. I talk about hair microscopy and blood spatter evidence, and shaken baby syndrome is something that I note in the book that is highly problematic. So the list of polygraphs, it goes on and on. There are many discredited techniques, but for my purposes, and the book's purposes, I think bite marks are probably the best or worst example.
Let me turn to Attorney General Ellison. You've just completed 2 very high-profile criminal trials as a prosecutor. Both of those involved a lot of expert testimony, a lot of forensic science on both the prosecution and the defense side. How do you approach forensic science evidence as a prosecutor?
Well, I mean, it's a piece of evidence, right? And it needs to stand up to scientific rigor. Honestly, we won't present evidence that does not meet those requirements because we're not in the business of convicting innocent people, right? Happens, and when it does, I mean, on the conviction integrity unit, we are very mindful of the problem of junk science or stuff that seems kind of sciencey but is not, so it's part of how we re-examine cases and go back and look at cases where there's been a prior conviction. But for us, it's important. It's just as important for the prosecutor to be rigorous and challenging, scientific evidence as it is in the defense counsel. We don't see it as just the defense counsel's job. It's the prosecutor's job. It's the court's job, because all of our job is to make sure there's a fair trial. And if you're going to deprive somebody of their liberty, it better be on something solid.
I just saw a chat that they're having trouble hearing you.
Oh.
I'm not sure why.
Let's see if the microphone is on. No, it is on. So just, I guess, hold it closer to your mouth. The Attorney General mentioned the role of the court as being one of the gatekeepers of this evidence. Chris, how is it that this evidence that lacks any scientific basis, how does it end up in our courtrooms? How does it end up supporting convictions?
There are many different ways that it ends up. There are many different reasons why. I think that really it begins with widespread scientific illiteracy around our country. Is that and lawyers are certainly no exception here, and maybe even more lawyers than the regular population. The old joke about going to law school because there's no math, holds true. So I think that's part of it. Part of it is that these decisions are typically made by one judge, and it's about one case, it's about one defendant, and that usually everybody in the courtroom, except for maybe the defense attorney, believes that this person is guilty. Very, very reluctant to remove a tool from the prosecutor's tool belt that will be useful in gaining that conviction. And no real thought is given to the systemic issues, right? And that one is particularly in forensics, unlike many other areas of the law, one decision, one Fry or a Daubert decision, these are the legal tests for the admissibility of scientific evidence in most states. One decision like that, because it's not litigated that often, will lead to be cited across the country. And I track the original bite mark case in my book and just show how it just spread like a virus everywhere without really any examination of the underlying claims. And we at the Innocence Project have been advocating for a long time for removing the job of validating scientific evidence from the adversarial system, that we need something like the FDA or something like that does validation research in advance of it being used in criminal trials, right? So we do this with toothpaste, we do it with aspirin, we do it with all kinds of consumer products for public safety reasons, right? But we don't do it with forensics, right? So you can get this junk science, if you can convince one judge, which is very easy to do, to bring it in, There's nothing standing between that and a death sentence, and I talk about David Wayne Spence in my book about wrongful execution based on bite mark evidence. So we really have to, because in the adversarial system, as Attorney General Ellison knows as much as anybody, is that when you get in court, the gloves are off, and that you're not going to be talking about good science, you're going to be talking about who's right and who's wrong, and that's really, I think, how it happens. I don't know if you have more to add. Or
who's more of a compelling orator,
Right.
or who's great at the theatrical aspect of cross-examination. There's just so many other factors that have nothing to do with guilt or innocence. And so, yeah, a trial really is, it's a poor place to decide on scientific efficacy.
Well, I thought what was so interesting in your book was how you commented about Daubert, which of course was a civil case. And that when money's involved, then people really care about if the forensics is right or not. And then it kind of dribbled over into the criminal justice. But, when lives are at stake, it's less of an issue than we're talking big money. So I knew Daubert was civil, but the way you framed it was really an eye opener. And I absolutely agree. The courtroom is such a miserable place to be trying to prove that, you're the scientist or whatever.
Yeah.
I was just going to say, in the way we qualify folks as experts, we just ask them a lot of questions, which all amount to, do you know what you're talking about? And the answer is never going to be, not really.
Yeah, and one of the things that I explore a little is creation. I was listening to your qualifications, right? And I was listening to the board certification, and I know that you're a fantastic and science-oriented expert witness and doctor and pathologist. And but what I learned really both through litigation and through research in the book is that so many of these board certifications are nonsense. They really require nothing more than paying your dues, right? And that there isn't any test. There isn't any demonstrated, ability to do what you claim to be able to do. And credentials are everything. You walk into court and you say, I'm a board certified forensic odontologist with the American Board of Forensic Odontology, and I'm a member of the American Association of Forensic Sciences, and so am I, right? It's just so that's a huge part of it, I think.
Yeah. And there's also, because of the adversarial process, there's a real reluctance for anyone to say, I don't know. And based on the evidence we have, no one can reach that conclusion.
I just want to say to your point about compelling witnesses, because I have certainly testified at the request of the defense to say, I don't know what happened here. And furthermore, I don't believe anyone can tell you what happened here. And then the prosecution forensic pathologist gets in there and says, I can tell you what happened here. It went down like this. Well, he has no more insight than I do, but he's willing to say, here's what happened. Well, who's the jury going to believe? This person that says, I don't know what happened and nobody can know. And well, what kind of a lame answer is that?
And I think related to what you were just saying, what you're both points that you're making is the trial pressure. Is that what happens is a lot of these opinions, and I talked about this in the Stephen Chaney case in the book, is that they start off pretty modest, right? Somebody that would maybe not be so conclusive, right? That somebody's maybe just consistent with the bite mark, or these two hairs are consistent with each other. And then you get closer to trial, and the trial pressure comes and the advocates come, and you have those meetings, and suddenly it's him, it's a match. And then suddenly you're on the witness stand and it's 1,000,000 to 1 that anybody else other than this person could have made that mark, right? So again, it goes back to the point we're making about how terrible of a place to suss out sense from nonsense is criminal court.
Well, let me take it out of the courtroom for a second and ask a question of Dr. Thomas, our non-lawyer on the panel. You said something interesting to me when we were talking about this upcoming discussion. You said the history of medicine is rife with things that have turned out to be junk. Can you elaborate what you mean by that?
Well, yes. And I think that's part of the challenge in lumping forensic medicine with forensic sciences is, if you go back far enough, that there was bloodletting. People thought that was a great idea. And leeches actually have kind of made a comeback somewhat. But yeah, leeches, I know, like, ick, right? Yeah, exactly. Or, the idea of evil humors causing illness. And then even more recently, thalidomide, great idea for preventing morning sickness. No, turned out to be terrible. DES to prevent miscarriages, except that then the children that are born have these bizarre cancers and things like that. Or, estrogen for postmenopausal women. Well, yeah, it does increase the risk of heart attacks and death, but they at least aren't having hot flashes. I mean, you just sort of think about all of the history of medicine and doctors, especially historically, now not so much anymore, but historically, they were used to being the expert. You went to your doctor and whatever he, and it usually was a he, said was gospel. And so doctors, probably worse than any other group, are very reluctant to say, you know what, for 15 years, I've been telling you to do this, but it turns out there's no evidence to support doing that. I think nowadays people, first of all, are a little more skeptical of, authority in general. But I think also doctors now recognize, we aren't always right. So certainly forensic pathologists, you live long enough, you have plenty of opportunities to realize, boy, I was so wrong about that. So, yeah.
Well, let me turn it to you then, Chris. In light of what Dr. Thomas is saying and the sort of evolving nature of medical science, of other scientific understandings, things change. We realize we were wrong about something. In terms of a court system and securing convictions, how have we, if at all, managed to deal with that evolving nature of scientific understandings?
Terribly. And you asked before, about why the reasons that judges will allow in unreliable evidence. And, the reason, apart from all the other pressures that we talked about, is case law, right? Because judges are going to make their decisions based on established precedent, not on established science. When they're looking as to whether or not a particular forensic technique is admissible, they're not going to the science books. They're not calling you, right? And they're certainly not calling me. That what they're going to do is they're going to look it up on Westlaw and see whether or not this evidence is admissible. And we know that, precedent doesn't change very often, right? Science is a process. It's always changing, always evolving, always abandoning hypotheses that have been discredited or falsified. So if we're going to use scientific evidence in the criminal legal system, which we are, we have to, and we're going to continue to do that, then we have to be comfortable with uncertainty. We have to not pressure experts to overstate their conclusions. And when they don't know, they don't know. And we also have to be willing to go back and correct the record. We have a duty to correct. We have an ethical, moral, and legal obligation to go back. If we introduced, I'm not a prosecutor, but if prosecutors introduce evidence that at the time, the consensus was it was valid and reliable evidence, but it turns out to have been wrong, like so many of the techniques that I talk about in the book, that we have to go back and use conviction integrity units, and courts have to be willing to do this. One of the most important things I'll be interested in your opinion about this, Attorney General Ellison, is that it was a novel approach with the Stephen Chaney case. That's one of the backbone stories in my book, is that rather than going in, although we went in to talk about his innocence, but really what the important thing was, the whole focus of our presentation that we write about, was so anxious about, because it was 6-7 years ago, and bite marks hadn't been quite discredited as they have been today, was persuading Susan Hawk, District Attorney Susan Hawk in Dallas at the time, and her team, that bite marks were unreliable. So we had to go in there and argue science, and she was, to her credit, willing to accept that, and then do the investigation. We would say, okay, I'm ignoring the bite mark evidence, right? And I don't think it was a fair trial. I also want to investigate the innocence claim, and she was willing to do something about that. And I don't know whether your thoughts are on that.
Well, I tell you, that's a very welcome development. I'm glad it went that way. We need to make it much safer for prosecutors to actually take a second look at cases. There's tremendous pressure to try to protect the conviction. And from an appellate standpoint, there's a high premium on finality. It's over, done. Was it right?
Right.
We need to switch that. And quite honestly, a lot of this is coming from voters. Voters are saying, I really care who's the DA. I care who's the AG. I care who's the, voters are demanding these things. And, the legitimacy of the system is really on the line when you're unwilling to even look at this stuff. And, from a prosecutorial standpoint, I can tell you there is a certain amount of disruption that's going to happen when somebody is told, that guy who's been in prison for murder, that wasn't right. It's like, what? And there's a lot of just human need to sort of want to say, well, no, I didn't want to lock somebody up for that amount of time. I was right. So now you've got to fight through that. And so I definitely believe that usually we did this historically when the defense counsel comes up and, brings us some post-conviction and then we find out. That's not going to be good enough to try to correct the wrongs that have happened. We're going to need prosecutors and we need voters to say, prosecutor, we want you to keep us safe. We want you to hold people accountable. But if you didn't get it right, we don't want you to double down on that. That's not what we want. And we live in a society where admitting mistakes is a very hard thing to do, no matter what job you have, right? And this is one of the more serious ones, dealing with people's liberty and life, as you pointed out. So I think the trend is positive. It does worry me when you see crime spikes, because whenever you see crime spikes, which are driven by COVID or whatever, right? The response is to be like less sensitive to the needs of justice, right? And just sort of like keep them where they are. We're not soft on crime around here. And and again, there are folks who will punish you with the ballot box for not being harsh enough, right? And I just hope that the electorate continues to want to see prosecutors who are trying to protect the public, protect public safety, but also have accurate results. So far, not so bad. There's been a lot of DAs who've been pressed to the wall and have won. Larry Krasner won, and there are others as well. And now you got this phenomenon where a lot of defense counsel are running for DA, so.
Can I just add one thing?
Go ahead.
One of the things I loved in your book was, and I'm not a lawyer, but I hang out enough with lawyers to know that this doctrine as the principle of finality is very big. And I loved what you said, that this is, of course, the opposite of science. Science is an iterative process that's always re-examining. So I think therein lies sort of the real tension, is this legal scientific.
Yeah, I mean, and you make a really good point about, the personal, right? Prosecutors go in and they try somebody in a criminal trial and send somebody away for life. Somebody like me comes along 30 years later and says, you know what? It's like, right? And I was privileged to be witness a scene that I included in the book where the trial prosecutor who prosecuted Stephen Chaney, is that we had all the other claims that were in his case have been basically agreed to and resolved by us in the Conviction Integrity Unit, but the Brady claims were up to him. It's like, was he going to, he wasn't the district attorney anymore. And, so we were heading into an evidentiary hearing, so it wasn't clear if it was going to be adversarial or it was going to be kind of ceremonial. And, it was like, is he going to admit error and admit that he was, that he had prosecuted an innocent person? And so we met in the judge's chambers because Stephen Chaney had already been free. And the two of them confronted each other in those chambers for the first time in 30 years, right? And I was so moved by my client, who was a very religious person, and they just looked at each other for, it felt like, a minute. It was probably 10 seconds, but it's like, it's like, and he just put his hands on him, both shoulders, and said, I forgive you. And he put his hands on, and they hugged and they prayed together in that room, and then he went out on the witness stand and apologized and said that he'd been misled by the junk science, and that was really, really powerful. And it's such a great example of what you're talking about.
Well, confirmation bias, right? So once you get it in your head, he did it. Then all you need to do is find ways to prove that he did it, as opposed to allowing the evidence to tell you whether they did it. I mean, I can tell you that I'm not gonna get specific today, but there are cases that we've had to review where, you know, people tell me about their gut feelings. I'm like, yeah, okay, but what about that evidence thing, since we're lawyers around here? Because if you take away this, and you take away that, and you take away that, what you have is innuendo and rumor.
Yeah.
And that can't hold up a conviction. So, I mean, but it is important to talk about the human element. And it is also important for the electorate to understand that a prosecutor who says this one needs to be, you know, flipped is not abandoning the responsibility to protect you. They're not giving up on the cause of accountability and justice. They're just actually what we say at the conviction integrity unit is that it's a double injustice to convict somebody, because maybe the person who did it is still never been held to account. So there you go. And by the way, we prosecuted 33 people in the last 3 years, 33 murders or sexual assaults. So it's not just the cop cases. We do them all. We do whatever the counties ask us to do. We're kind of the prosecutor of last resort in Minnesota, and you know usually we're in Greater Minnesota.
Right.
Usually we're in Greater Minnesota. So.
I mean, just to add a little, I'm sorry, Jim, Jim, is that what you were saying about, you know, the prosecutor is not abandoning their public safety role by overturning conviction. And really, I can't remember the exact number, but a huge percentage of our cases that the actual perpetrator went on to commit many, many serious violent felonies, right? You know what I mean? So it's a public safety aspect to it, you know, in both ways.
Exactly.
Yeah.
Couldn't agree more.
We've talked a bit about the principle of the finality of judgments and about the work of conviction review units in reviewing convictions. Attorney General Ellison, I'm wondering if you could just introduce the audience to the Minnesota Conviction Review Unit, really what it is, why you undertook that initiative, and how you balance this work of reviewing convictions with this principle of finality.
Well, so I was in Congress for 12 years. And before that, I was a defense attorney for about 16 years. So when I got to be attorney general, I mean, I knew I'm a prosecutor now, you know, and I believe in keeping people safe. I think everybody has a right to walk out to your car and no sweat, right? I definitely believe in public safety, and I'm okay with holding people accountable. But maybe my defense attorney impulse is also like sort of make me really rebel against the idea that we're just gonna do whatever to convict somebody, right? There's got to be some fairness, and if the person's truly up to no good, they'll get caught, right? I believe that. I have faith in that. But it really wasn't my idea. It was some folks. I think, you know. Do you remember? You came into my office with Don Lewis and F. Clayton Tyler. Is that right?
Right.
And you want to introduce yourself?
I'm Julie Jonas. I know a lot of people here.
Yeah.
Jonas, I'm with the Great North Innocence Project, I'm the legal director.
So I'm minding my own business. And here comes Julie Jonas and these two guys. You need to set up a conviction integrity unit. They were actually quite nice about it.
They're nice.
All right. And so I thought about it and I'm like, good idea, but I'm already pressed to the gills on you know, with money, you know what I mean? You know, you're talking about spending money. That's tough right there. So they said, you know, we can help you with that. So they applied for a grant and then were a pass through to us. So that started us out. And we're continuing to just work and build resources. Now we have a executive director. We have a paralegal. We have a lawyer. We have law students helping us. We have a great community board that meets on a very regular basis, takes their work very seriously. And we are moving cases. We have not finished a case yet because we've only been live for like, how long, Julie? Like a year?
Yeah.
And maybe not quite that, but you know, so, but we have them, we're close on a few. And I'm not trying to, don't put me on a time clock, but I am anticipating that there will be some folks who are going to see freedom. And I wouldn't say that unless I was pretty sure about it, because you're supposed to under promise and over deliver, right? So that's what it is. We have a great community board. We have, Justice Paul Anderson's on our board. We have on the board several folks, Fred Freeman, who is a former public defender in St. Louis County. We have we had Leslie Redmond, who was the head of the NAACP in Minneapolis. We have Eli Darris, who spent many years in prison himself and was freed based on, he was actually convicted as a juvenile and he didn't get out till he's like in his early 30s. But he is a brilliant human being. And if you ever meet him and you find out that he spent time in prison, it'll probably surprise you, which is interesting because well, who do you think is in prison, right? Who do you think? There's a lot of talent in prison. And there's also, but he's a brilliant guy. And I've actually asked him if he would consider going to law school because I think he'd be really good at it. And we have a lot, I'm sorry I missed anybody who's on there because we got great people. We got some folks here who are in there, Jim's there. Julie, you're on there. Oh, yeah, old prosecutors. We got John Schmidt. We got David Voigt. We got me. We got prosecutors. We got defense attorneys. We got community people. We got judges. We got community leaders. We're up and running now. And Carrie is when we opened the opening weekend, I think we got like 700 applications. Obviously we can't do all those, but and many of those probably wouldn't meet our criteria. Right now, we're looking at claims of actual innocence. We hope, once we do enough, that we can one day look at sentencing, because there are a lot of people who I do in life who, when you hear their story, it's like, wow, really? So for example, guy says, you, my girlfriend, come with me. And then the guy shows up at some guy's house, drops a gun in his face and says, you're gonna give me that money you owe me. They scuffle, guy gets killed, somebody gets killed, or maybe the guy just shoots him. He says, do something with this. The police arrest, and he says, yes, I did it. She has the gun. And if I'll plead guilty, I'll take a second-degree murder, thank you. And she's like, I didn't do anything. I didn't plan this. I didn't shoot anyone. I didn't do anything. He gave me a gun. I convicted. Life without the possibility of parole. Yes, we do that. And is that, I think most people would say that's not right. You shouldn't get more than the shooter planner, right? But she did, and there's not much a judge or the prosecutor can do about it because it's mandatory sentencing, which is another thing. We want to also not just take cases and maybe do sentencing. We want to take a cue from you, Chris, and try to advise the state on what good, solid practices are. So if you are going to prosecute and convict somebody and take their liberty away, that we do it based on a higher degree of certainty that they actually did what they're accused of. And again, one of the things you could put in that book is just public fear after a high profile murder. Whenever there's a high profile murder, and we live in the world, so there will be those, the justice gets very much on the ropes during those times because the pressure to get anybody is very high. So we want to do that. So those are the three things we want to do: actual innocence, hopefully one day sentencing, but we certainly want to put some of Chris's ideas into policy, and to make sure that we actually are doing them. Like, we did that with witness ID and the sequential IDs and taping your Mirandas, and there's been a lot of progress.
Interrogation is very important.
Yeah. So, and so this book is very welcome, and I look forward to really digging into it and staying in touch.
Me too.
Yeah.
I think I just want to like point on it's not related to my book, but it always strikes me is that we have the highest incarceration rate in the world, and we also have amongst the highest rate of violent crime in the world, right? So it's obviously not working. Locking up all these people, right, is not solving violent crime.
But some people would say it sure feels good.
Right. Yeah. Some people, yeah.
Some people.
Chris, what do you see as the role that conviction review units play or that they could potentially play in keeping junk science out of the courtroom?
As a longtime defense attorney before I came to the Innocence Project, I was deeply uncomfortable with the whole conviction integrity unit process because it's very collaborative. And you really have to just be, willing to, be straightforward and transparent with people that, you've been your adversaries your entire career, and kind of letting your guard down and having a joint reinvestigation. And you really have to be pretty confident of your case. And it was against all of my instincts, right? As I have to say. And it really took, Patricia Cummings, who's a character in the book, who's a phenomenal head of a couple of Larry Krauser's most recently of his conviction integrity unit. And, so she's a very science oriented person. And we just developed a level of trust with her, and that, so I think that was a huge part of it. And that she was also willing to think about the, not just and what was important because it was in Texas. It's not just, she personally believed, I think, and I don't want to speak for her, that bite marks are junk science, but what they testified in his trial, in Stephen Chaney's trial, was that there was a 1 in a million chance that anybody other than Stephen Chaney could have left that bite mark. And so I think that was enough for her to, employ what Texas has also something known as the junk science writ, where if they ought to have one in Minnesota, is where if you have been convicted on science that has been subsequently discredited, then you have a path back into court to have that conviction looked at. So we were using both those things, and that was in conjunction.
We're going to research that.
Yeah, add to the list.
Yeah, it's important. They have them all over now. There's one in Michigan, there's one in Connecticut, first one was in Texas. They're trying to pass one right now in California, and it makes perfect sense, because as we were talking about earlier, we're using scientific evidence and we know science changes. There's no other way around it, right? And so what we know today, right?
Well, here's the thing. How in the world does somebody get away with saying in a courtroom, there's a 1 in a million chance of this? How would you even know that?
I'm almost as sure as my Lord and Savior, Jesus Christ. Somebody said
I'm like, are you kidding me? No,
but the truth is, though, and that testimony is being given right now today in courtrooms around the country, everywhere, right? It's called individualization. They're claiming the ability to identify one bullet to one gun to the exclusion of every other gun, every manufacturer in the history of time is more than 1 in a million. It's 1 in a trillion, whatever it is, right? So these are not, one-offs. This is, not like, random testimony that came out in one trial. It convicted an innocent person here.
But Chris, if you're gonna go and sell toothpaste,
right,
you probably would, I don't know, try it out, test, see how it goes, right? Have some data to be able to say, something. That's not a testable hypothesis.
Exactly.
And yet here we are.
One of the others, and if I'm giving you a laundry list of wishes for the state of Minnesota is a forensic science commission while I'm here, right? Because that's also a big part of what they had in Texas that was very important to Stephen Chaney's case as well. It's one of the reasons that I wrote so much about his is all the different reforms that had to be in place for his freedom, because with that conviction integrity unit, they still had to have the High Court of Texas sign off on his actual innocence, right? So even though everybody had agreed at the trial level, it still goes to the Texas Court of Criminal Appeals, the state high court. So everything that went into that was the NAS report. The Texas Forensic Science Commission had weighed in on bite marks by that time and had issued a report and calling for a moratorium on the use of this evidence. There was a conviction integrity unit who had investigated so it really, to coin a phrase, it took a village, right? To get it done, it really everything. You had to have great lawyers on all the sides. You had experts that from the forensic odontology community who were willing to say, I was wrong, you know what I mean, which is also very unusual. So all that, and that what is really keeps me up at night is that he won the lottery. He was 1 in a million, that we took his case, right? So there's 2.3 million people in prison, right? You know, if 1% of them are innocent, we're talking about tens of thousands of people.
Yeah, that's a scary proposition.
Chris, you talk in your book about what I would describe as some truly bad actors, sort of repeat offenders when it comes to introducing evidence that they know has no validity. What kind of accountability have we seen in our system for the experts or the lawyers responsible for admitting the worst of the junk science and convicting innocent people?
None.
How many exonerations does it take per expert before that expert just is, I mean, that's what I want to know. Like, one would be enough to scare me, but these.
Yeah, I mean, the other kind of backbone case I talk about is Eddie Lee Howard in Mississippi. And for those of you who maybe watch the Innocence Files, you know, and on Netflix have seen a little bit about him, or the is one of the most notorious junk scientists in the annals of junk science is Michael West. And, you know, what was astonishing, because he'd already been discredited when I was, you know, made part of that legal team. He had 2 wrongful convictions, Kennedy Brooks and Levon Brewer, who were both exonerated by Vanessa Potkin and Peter Neufeld of the Innocence Project before I was even there. And then I was added to this team. And what, not only had he been totally discredited in all his methods, but in Eddie Lee Howard's case, there was no evidence. In other words, there was no photograph of an alleged bite mark. There was no outline of his teeth. There was no moles. There was no nothing. It was just this guy getting on a witness stand and all shucksing it through trial and claimed that there were bite marks that he found and matched them to Eddie Lee Howard. And that was enough. Zero evidence. This is oral assertions, you know what I mean? And so the idea that there's real accountability here, you know, and I something else that I write about, it's the reverse. Right, is that you'll get dissenting experts within the field, right? Like the American Board of Forensic Odontology had a couple of dissenting experts. One of them became such a threat to the enterprise that they filed ethics complaints against him. It happens in forensic pathology, right?
John Lentini and Fire.
John Lentini and Fire, right? You put your name out there, and the vested interest will go after you in a really, really strong way. It happens to shaky baby syndrome experts who are willing to testify in that, right? It happens a lot. So those guys are the heroes, the ones that are willing to stand up for science and stand up for innocent people, be willing to suffer the slings and arrows. And I always say that to the experts that are willing in our cases to speak the truth about the science, we will help protect you. You know, I will get pro bono law firms to give you $1 million defense, you know, I mean, if you're willing to speak the truth in court. And that's what it really takes, because very, very few of these experts have the wherewithal to defend themselves against, specious attacks, you know what I mean, that are really contrary to good science and certainly contrary to justice.
It's a really good segue into talking about some of the kind of hitting head on some of the ethical issues that we're dealing with. Either Chris or Keith, how would you describe the ethical duties of the prosecutor when it comes to reliance on forensic science?
I think we have an ethical duty to rely on legitimate science and an ethical duty to reject, specious junk, unsubstantiated science. That's easier to say going forward than going back for reasons that I just said. But at the end of the day, if somebody's liberty is deprived of them because of something that just isn't true, how can you ever believe that they're guilty unless there's some other evidence to support the conviction? So I think the ethical duty is pretty clear. We're told ministers of justice, you're not just a belt notch and convict people. We've already talked about the human element of that, but I think we just need a lot more. That's why I'm never really a fan of the term progressive prosecutor, because the term progressive prosecutor sounds like that's a different kind of prosecutor than a regular prosecutor. A regular prosecutor.
Retrogressive prosecutor.
Right. But when I did a death penalty case in Louisiana, I was shocked to hear people talk about, going to the Friars Club luncheon. You know what I'm talking about? You don't get in the club until you kill someone.
Oh,
you know, you've got to get the death penalty act, and they have lunch and talk about, just do it.
Actually carried out. in other
Yeah,
words.
yeah. So like you've got to, charge somebody with a death eligible, get them convicted. They go to the execution, then you get an invitation to lunch. So the thing is, that we've just got to get prosecuting and policing back to what, closer to our ideals, but now it's all wrapped up in war on crime, war on drugs, racism, class bias, just disrespect for poor people, because this just doesn't happen to anybody. It's important to remember, this hits, what was the white guy in Wisconsin who lived in who making a murder?
Oh, yeah.
Stephen Avery.
Yeah, now Stephen Avery was not a Rockefeller, and what's the guy name? Curtis Flowers was not a Rockefeller, and this hits a certain segment of our community harder than others, and we've got to keep that in mind. And as a prosecutor, I think that you really should, keep in mind that the most defenseless people probably you have a higher ethical obligation to make sure that if they're convicted on evidence that you would trust, and sustain some scrutiny.
I would just add to that, though, I think it's the rare attorney, to what Chris said earlier, who knows any science. I mean, the joke in college was if you couldn't pass organic, then you went to, then you went to law school, and but I mean, I think it's really a challenge when attorneys who are responsible for making these decisions and judging the validity have so little science background. And that was one of the things we've talked about, the NAS report, and I'm assuming everybody knows that that was the National Academy of Science in 2009 that was critical of forensic science. But one of their basic things was we have got to start teaching science to judges and lawyers because it's in their hands, this decision.
Well, I think you're right, and I want to agree with you, but I also want to say this. I'm not sure you need to know science. You just have to be skeptical of claims that kind of sound like BS. Oh, 1 in a million person did this by Mark. I mean, common sense should tell you, really? How do you know that? Who are the million people you've done? These DNA, there's been millions of people. We know because there is a provable proposition, not bite marks. And anytime you talk about matching evidence, when you put a number on it, it's real problematic when you start putting a number on that. You can just say that looks like that, and the jury can say, well, so do a lot of things. But once you start putting numbers on it, something is consistent with something else. A lot of things are consistent with other things, right? It doesn't mean that much, really. So I would say that it is important for us to be skeptical of claims that are problematic, and we take the time. Another problem is the rocket docket, right? How many judges have I been in front of where they're just impatient? I can't take all afternoon with this counsel, and they're going to move this through. They're going to make this go through fast. And I'm like, can we just see whether we're talking about is solid? I remember one time, I had a case in Watertown, Minnesota. 3 people were shot to death. And they wanted to say that this batch of bullets that we found in the home of the defendant was the same, came from the same batch as the bullets in the bodies.
Comparative bullet analysis. You had
Yeah.
a CBLA case.
Yeah, that's what I had. And and that we were able to persuade the judge that it wasn't there was just too attenuated. It was too weak. It was too much guesswork, and so that was it, and it just didn't make sense. But the judge was willing to listen. And so I give this judge a lot of credit. Judge Goggins out there in Carver County, I'm sure he's long retired, but I was grateful that he would listen. Some judges that are just sick of it, tired of it, hurry it up. And, and then, by the way, as a prosecutor and a former defense attorney, I could say that the defense bar is not blameless here. I mean, I've seen defense counsel mail it in, I mean, can we admit that?
Absolutely.
And
And they have the same kind of push.
well, they might have a ton of cases and, but you've got to take the time and be skeptical. And that's what we really need to do. And I like the point Chris made. We got how many 2.3 million people in behind bars? I mean, I think that we can take the time we need to, to do justice right. Yeah.
Yeah, I always want to make it clear, because you brought up racism and we hadn't talked about that much, but junk science is really the symptom of a much larger disease, of systemic racism, mass incarceration. It's a tool that props up the status quo, and unquestionably, we talk about some of the volume issues that contribute to that, and some of the things I don't talk about in the book, but things like presumptive drug tests, where you're really doing volume people, right? You might, have 30, 40 people come through arraignments, and that a lot of them have been tested positive of a pipe or something, like some pill in a car. Those are often at best flipping a coin, also subject to confirmation bias. And a lot of those folks have to plead out because they're not going to make bail, right? And so you have maybe 5, 10 wrongful convictions a night on junk science.
You pled guilty to something because they said if you plead guilty now, you can get out.
Right.
But if you want to fight your case, you can sit in jail. That ain't no way to run a justice system, man. But we've got to get somebody to say no, anyway.
We talked earlier about, we've talked about race, we've talked about the role of socioeconomics, and Lindsay referred to this part of your book. Chris, at times you refer to junk science in the courtroom, at least in the criminal courtroom, as poor people's science. Can you elaborate on what you mean when you call it poor people's science?
Yeah, Lindsay mentioned this a little bit. So the first, in the 60s and 70s and the early 80s, the legal system in our country really, grew exponentially, mostly a result of mass incarceration and the criminal side and the drug war. And on the civil side, it was product liability, personal injury, mass tort litigation, and all the rest, so a lot of lawyers got very wealthy during that period. And a lot of corporations took some hits on a lot of very suspect expert witness testimony. And so corporate defendants were interested in getting better science in the courtroom. And, it makes kind of an ironic bedfellow for us, but they teed up this case to go to the Supreme Court to try to flip the script as far as the use of scientific evidence in courts. And what the Supreme Court decided was that in this case in Daubert, federal judges, and then it was adopted by virtually all the states, except for some of the most populous states.
Not Minnesota.
Right, not New York and not California and not Pennsylvania too, but the idea is that they were going to act as gatekeepers, right? And so rather than deferring to the relevant scientific community as a Fry test, they were going to actually have to apply basic science to the proffer of expert witness testimony. And it worked, for civil defendants, so corporate defendants primarily, and, the odd, loner, but there's empirical evidence on that they started excluding unreliable evidence in much greater rates. Peter Neufeld conducted a study about 10 years after Daubert that showed that criminal defendants benefited not at all. A vanishingly small number ever challenges to what we know in junk science, was still admitted in court. I did a follow-up study with Brandon Garrett in 2018. Same thing, still today, is that courts are unwilling to exclude unreliable evidence in criminal trials. And so that's why I'm calling it poor people's science, right? Because it's working, in civil litigation where money is at stake, and it's not where life and liberty is at stake, and the difference really speaks to our volumes as a society, and who it is that's being prosecuted, who's the subject of mass incarceration, right? These are poor people and disproportionately Black and brown people.
I want to circle back to ethics again and justify that 0.5 credit that folks in our audience are getting. Chris, I'm going to ask you a question that as a defense lawyer makes my head hurt. So I apologize in advance for asking you this question, but what about when the tables are turned? You're representing a criminal defendant and you have the opportunity to rely on science that you believe might be suspect in order to defend a client who you believe to be innocent. Where do you see the ethical boundaries being drawn in that situation? Look at the time. Yeah, I'm going to have to wrap up.
It's funny because we had a panel about this at the Innocence Network conference last week, so one thing I should say is my role at the Innocence Project, I would never proffer junk science or something that I subjectively believed not to be reliable. And I have very niche like litigation in my practice, and where I work, we have a policy department. So it's a much more complicated question for somebody like me. So there's that answer, right? And if you're talking about just the defense bar or when I was a public defender, sadly, you can't really handicap your client because you have a subjective belief that you may be the only person in the courtroom. The judge is going to let in everything that the prosecutor is going to proffer. This evidence is still admissible. So you're saying that because I have some higher minded purpose beyond my client, you can't have a higher minded purpose beyond your client. If you have a tool that is going to be useful and admissible and ethical to proffer on behalf of your client, I would hope you wouldn't need that, but I could never tell, a defense attorney not to use all the tools because we know it's being done on the other side. So it's like a fair playing field, and I think about this in terms of bias. And I talk a lot about cognitive bias in the book, is that we know, and one of the NES reports, one of their essential recommendations was to separate the crime lab from law enforcement. And how important that is, right? Because if you have scientists that are viewing their role as catching bad guys, you're going to have a lot of real problems with, because these techniques are almost overwhelmingly subjective, some much more than others. But when you have subjectivity, you have bias, and you have somebody that looks at their role as being, essentially a cop, then you're going to have bias. And if you have prosecutors that are talking to their experts about their case theories, or if they're in the autopsy room with, or the detectives are in the autopsy room, you're going to have bias. So what do you do as a defense attorney? Are you going to not bias your experts because you're going to have a pure opinion? I do, because of where I work, but I don't know. I don't know what the right answer is for that.
Well, I'll say two things. One is rules of professional responsibility. You have a duty to be truthful. Can't lie, cannot lie. But it's also true that defense counsel and prosecutors don't have the same ethical obligations. Defense counsel has the obligation to be a zealous advocate. So let's just say you're not sure it's altogether right, but you've had a few doubts, but you do believe it's right, at least in this case. I don't know. I think you may have an obligation to bring it forward. And if it's the prosecutor's job to challenge it. But you can't do it if you know it's BS, but maybe if you think it's, pretty true and true in this case, maybe you have to bring it up because you have to be a zealous advocate.
Yeah, it's a very, very tough question. And we used an article called Soft Core Perjury to talk about it. I didn't make it up. That's the name. I think it's in the Penn Law Review. I don't remember, but it's talking about those things that you know to be true. And what you don't know, like a lot of, public defender or defense counsel, they, what do you know to be true, right? If you weren't there, there's very little that you actually know. In science, what do you know to be true? That's tough. Bite marks, we can't do bite marks, right? But
in fairness, Chris, I've been throwing you softballs right up until that question. Dr. Thomas, I want to ask you about ethics in terms of scientific expert witnesses. We've got battles of the experts in court all the time. We've got two experts in court raising their right hand, swearing to tell the truth and saying completely opposite things. When does it cross a line into being an ethical breach from your perspective?
Yeah, where are those softball questions exactly? So I can obviously only answer this as a physician, forensic pathologist. And the way I think of it is doctors have differences of opinions all the time. Everybody's familiar with, you get a bad diagnosis, you're going to ask for a second opinion. And the second opinion may be completely different, or probably more often it's just going to be slightly different. But, and it's a challenge because so much of this is based on your training and your experience, which I know you kind of diss as, you know, ways of.
Not yours.
Yeah, right. Well, but I mean, it's a fair criticism because suppose you're a cardiothoracic surgeon and someone comes to you with coronary artery disease. Well, obviously the treatment is going to be a coronary artery bypass graft, right? But suppose you're a cardiologist and someone comes to you with coronary artery disease, you might say, well, let's give it a trial of medicine and diet and exercise and, you know, sort of follow you for a little while before we crack your chest. So it's based somewhat on training, experience, in pathology even. So that's general medicine, but in pathology, you know, we have criteria for what a diagnosis of breast cancer is supposed to be. But one pathologist might look at this and say, yeah, I would call that cancer. And another pathologist might look at it and say, you know, it's atypical, but it just isn't quite enough for me to flip that switch and then know that that patient is going to go down the cancer path. And in forensic pathology, it's so dependent on your prior experiences. You know, for example, I've seen in my career some really bizarre, weird suicides. So when I see an oddball, suspicious case, the first thing I'm going to ask myself is, well, could this be self-inflicted? But if you're someone whose only suicides have been contact gunshot wounds to the head or hangings, and you see a really kinky, weird case, you're going to think, oh, well, it's got to be a homicide because I've never seen anything except regular suicide. So it's, but are those ethical breaches or are those just, you know, lack of imagination or inadequate training or not keeping up with the literature, not attending conferences, not, you know, so it's really a tough one, I think. Certainly every once in a while you hear a testimony and you just think, well, they have got to know that they're lying through their teeth. They just have to know that. And so those are the ones where you kind of are like, okay, well, that's unethical to say whatever. But I would say, at least from a physician's perspective, it often is just slightly different interpretation of the data.
Yeah, I've got a lot more questions I could ask, but I did want to save some time for audience questions at the end. Before we do that, I'd like to just thank again our panelists for being here and for this great conversation. I've already got one question from the audience, and this is for Chris. It's about the role of precedent. And it's a good question because it's something that comes up a lot in your book. If a state Supreme Court found that some form of junk science, for example, bite mark evidence, is admissible, does that then preclude the defense from arguing in the trial court that the science has changed? In other words, is precedent just going to control in that case?
Well, that's what I do in trial courts every day, right? Is make that argument. Sometimes it works and sometimes it doesn't. It usually doesn't. It's, I mean, it really depends on the case. You know, one of the things, you know, I'll talk about a contemporary case that's not in the book, but it is based on some of the case law precedent that I talk about, in that the Charles McCory case in Alabama right now, they adopted, you know, the same reasoning of the original bite mark case in the 80s, in this case called Hadley in the Alabama Supreme Court. And what they said, and this has been true with a lot of the pattern matching techniques that we've been talking about, is that these techniques are so basic that, you know, you're just talking about matching two things. They did with hair microscopy, which has been responsible for at least 75 known wrongful convictions, that one forensic technique, at least in part, and that jurors won't be misled by this type of testimony because, you know, they can see with their own eyes whether or not, you know, these two things match, and they won't be misled by expert witness testimony. And so they're not going to scrutinize it the same way that they would other kind of whiz-bang technology. So that precedent, the pernicious influence of that precedent across the country has been, and I talk about it in different cases in the book, but just really recently is that Charles McCory, and I won't go deep into the details of the case, you can Google his name and you'll see that you know, there's a good couple of articles about him. He's innocent, you know, I have no doubt about it. We don't have DNA to prove it, but we have, you know, very clear alternative suspect and evidence pointing away from Charles McCory. And the only physical evidence was used in this case was bite mark evidence. That was introduced by the original bite mark guys from the Ted Bundy trial. They all became famous in Ted Bundy, and he was very active during this time. But to his credit, Dick Souveron recanted his opinion in our case in Alabama that I'm doing with the Innocence Project is doing with the Southern Center for Human Rights. And we had this affidavit of him recanting his opinion. The court cut and pasted the prosecution's brief after our evidentiary hearing into the opinion and said that because of this reasoning in the original case, that jurors are not going to be misled by this and that they could just see with their own eyes, that the recantation didn't matter because you don't even need an expert witness. You could just have the jurors look at this evidence themselves. So Charles McQuarrie is still in prison for the rest of his life today, based on legal precedent.
But the question is, are you bound to just abide by the precedent? The answer is resoundingly no. As a lawyer, you can say that a case was wrongly decided, and you probably should, often, and so, I mean, think about it. If Thurgood Marshall was stuck with that, he'd be arguing Plessy, but he said, this is wrong, and here's what you should do, Judge. And so I'd say whoever asked that question, challenge him.
Right. You're just not allowed to ignore the precedent.
Yeah, you gotta tell the judge, this is here,
right?
but it's wrong,
I'd also just add that there's increasing support in federal courts around the country in the case law suggesting that there is a due process right not to have a conviction stand when the conviction is based on, since discredited or debunked science.
Yeah.
Other questions? Alex?
Yeah, I read your interview with Slate Magazine, and I don't know if you saw how it was finally published, but
Sure.
they talked about it in the context of Ketanji Brown Jackson being appointed to the Supreme Court and her past as a federal public defender, maybe having, a role in helping, pave a way for the Supreme Court to do something about this, while being a realist about how much one justice on the Supreme Court can do. Do you think that there's hope with her on the Supreme Court to make some of these changes?
For the benefit of the Zoom audience, the question was about the new Supreme Court Justice Ketanji Brown Jackson and whether there's some hope, given that she has a criminal defense background, whether we could be moving in the right direction on some of these issues.
Well, first of all, like a lot of my colleagues and friends around the country celebrate, the historic confirmation of Justice Jackson to the Supreme Court. And sadly, from my perspective, not everybody certainly, that court as currently constituted is probably going to be that court for the remainder of my career and probably my children's careers, right? So one justice is, and that is the ability of one justice to create great change on that court, probably not. That said, dissents are powerful things. And she's going to be writing a lot of dissents, I presume, and that the reasoning of dissents are for, a more just society down the road, and they matter. It's not just, somebody pounding the podium. So I think that the perspective will be important. And I will say, though, often that, what we anticipate from any judge when they get on the bench is often not what we get, and I know lots of former public defenders who have been hang'em judges, shockingly, so I don't know Justice Jackson. I've never appeared in front of her. I don't know what she's like. I'm sure she's not soft on crime like they were trying to make her, out to be, so, I hope. I try not to be too cynical about these things. I don't know. Do you have an opinion about that?
Yeah, I actually do. So, what you said is absolutely right. There have been a lot of people who ascend to the Supreme Court and they do what we didn't expect them to do. I think Warren was the one who ordered Japanese internment, and yet he's also the author of all these amazingly, good cases. And so I believe that the odds of any endeavor change the second you've decided to fight. So always fight. Because the moment you say, well, we're gonna try to do this, we're gonna get this done, things can flip quickly. And I think Kavanaugh was one of the people who voted for Curtis Flowers to walk. So you never know. I mean, things can go in directions that you don't really anticipate. The only person who's consistently like bad on everything is Clarence Thomas. So, that you can count on. So, but other than that, you never know. So, I mean, I think that she can be influential when she's walking around, Hey, I need you on this. Hey, I need you on this. You know, you might be able to get some of them to do what's right. I mean, certainly Scalia was influential, was he not? In a bad way, in my opinion.
I love your optimism. Every single answer is, well, the electorate. You trust the electorate. God bless you. I mean,
Well, it's kind of.
I know. I'm so grateful for public servants like you who trust the process.
Well, I tell you this, in 2012, when they first put on the ballot that photo ID, who remembers that?
Yeah, oh, yeah.
So when it first was polling, like 86% of the people thought it was good. So I was representing the 5th congressional district, where if you don't win by 25 points, you've had a bad run. So I said, I'm gonna devote my whole campaign to defeating this. So 86, then we started talking, we started working, 84, 83, 81, 79. Then, if you recall, Governor Carlson jumps in, Governor, who was the, Dayton jumps in, and they push it down. Next thing you know, we're like 50-50 by election day, and it ends up being defeated by 46, 54. So my point is, don't ever count yourself out. And if you're going to do defense work, you're not going to win all the time. So you got to stay. I'm going to tell you, it's bad for a defense attorney to be cynical. Am I right? It's not a good thing, because you can get used to losing, and you don't ever want to do that. You've got to always make them prove it beyond a reasonable doubt.
Yes, over there.
I listened with interest at the discussion about how in an individual case, it's very difficult to get a judge to say, well, I'm going to keep out the bite mark. I'm going to keep out the tool mark examination, the shoe print examination. And as a longtime criminal defense attorney standing next to people accused of killing 2-year-olds or entire families, that has been my experience. And so, and I appreciate, sir, this is before your time as Attorney General, but in 2016, the Presidential Council of Advisors on Science and Technology issued a report on forensic science, specifically bite mark hair, footwear, firearms, and tool marks, saying these things should not be used, or they should be used in very limited circumstances. That report was resoundingly rejected by Loretta Lynch from the United States Attorney's Office. I am wondering if thought has been given in the Minnesota Attorney General's Office, and I appreciate you do not prosecute all the murders or even most of the murders in the state, but as being a leader in this movement, have you considered instituting policies before we're standing next to somebody who maybe killed a 2-year-old, right, as guidance for your office that we don't use bite marks, or we will only use tool marks if they use the following language, or we resoundingly reject hair comparison in every circumstance because things of that nature, as a leader in Minnesota in rejecting junk science?
Question about the 2016 PCAST report and the kind of statement made in there that certain types of forensic evidence may be inherently unreliable, and whether it would make sense to take a proactive stance before becoming confronted in an individual case and just saying we're not going to rely on X, Y, and Z. Go ahead.
Well, I'm not going to commit right here, right now, because I haven't read it. But, we have, that's one of the reasons why we set up the Conviction Integrity Unit, to do proactive stuff. You might recall, I said actual innocence, sentencing, and then looking at stuff like you just laid out there, say, should we be doing this? Because I think, let's just say we look at that and there might be something in there we can get on board with. I think even though we don't do most of the cases, we are the Attorney General. We're the only one who operates on a statewide basis. So that could well be influential. We could talk to the County Attorneys Association about it. I mean, I see it's a good enough idea for us to take up and look into.
Just to add one thing about related to that question is that, there have been a number of, mostly in federal court, but some in state court, that published opinions that have reined in some of the individualization opinions I've been talking about before, like one bullet to one gun to exclusive everyone in the planet, right? All of those cases, and I'm not applauding this fact, but it's just a fact, is that when they went to trial, those defendants got convicted, right? The sky didn't fall. The criminal justice system didn't collapse, right? So they could have gone to trial. They could have grossly overstated the evidence. And then you have an unreliable verdict because we know it's based on something that's misleading testimony. Now they went to trial. They didn't like it. They wanted to go much further, but they still got their conviction. So, it's not, this argument that we're not going to be able, to prosecute criminals as a result of some adopting what we know to be the limitations of the science, at least as we sit here today.
No, I agree 100%. We don't want to say it that this is the end of criminal prosecution. Of course there will be. Look, when I did criminal defense for 16 years before I went to Congress, and I'd say about 85% of my clients did somewhere in the ballpark of what they were accused of. I mean, right? Which is still 10% is a lot, right? But a lot of times you are just trying to negotiate a plea, right? And yet at the same time, as a prosecutor, I don't want to believe that I've changed the way I look at justice. I didn't think crime was a great idea when I was a defense attorney, and I don't think wrongful convictions are a good idea now that I'm a prosecutor.
That's a perfect note to end on. I hear the barbarians are at the gate. We need to clear out of the room. I want to thank the panel for a great conversation. Junk Science in the American Criminal Justice System. Copies in the bookstore right down the hall, and Chris is going to stick around to sign your copy.